Mr. Brown had a home in Bondi, but wanted a more expensive home in a posh suburb called Cremorne. He cooked up a scheme which he thought would allow him to use the interest payments on the new mortgage as tax deductions. That would reduce his tax and let him afford the house. Now, Mr. Brown was a magistrate but had no real understanding of tax law. He consulted a solicitor friend, Mr. Love, who wasn't sufficiently knowledgeable either. Mr. Love then consulted a tax accountant named Richardson. Richardson suggested a slightly different scheme, still with the intention of making the interest payments tax deductible. He explained the scheme to Mr. Love, who didn't really understand it, and Mr. Love then explained the scheme to Mr. Brown, who definitely didn't understand it, but who decided to go with the advice. Like any other legal decision, this decision had risks. The key risk was that the tax commissioner might decide to disallow the deduction, in which case Mr. Brown would be in all sorts of financial trouble. You can guess what happened next. Mr. Brown went ahead with the scheme, committed all the money, and the tax commissioner said no. He ended up having to sell both houses, the Bondi house and the Cremorne house, at a loss. So he ends up with no house and no money. He sued for negligence. The court found that there was negligence and that much of the negligence arose from the failure of the two professionals to give understandable advice, which let Mr. Brown properly assess the risks. Justice Brownie said, "It seems to me that it is clear law that if someone such as a professional advisor has a duty to give a warning, then the warning must be given in terms which are likely to be understood and appreciated by the recipient. Just as an employer sometimes owes a duty of care to an employee requiring the giving of an appropriate warning, that is to say, a warning which would be appreciated by the particular employee in the circumstances prevailing rather than employees generally, so it seems to me a person giving professional advice has a duty to give the warning in terms that are likely to be understood. This case teaches us that when solicitors communicate with clients, the solicitor must do so in language that the client is likely to understand."